Everybody will please get their seat.
Can we push it?
On.
Can we push it?
There we go. All right. All right, ladies and gentlemen, thank you all for being here. This is a Blue Ribbon Study Committee. We had a resolution in for a different committee, but this Blue Ribbon, I think, gives us more area to cover, and not just the issues that are going to be here today. We will cover later in other meetings around the state. I plan to have 2 extra meetings, one in the middle to southern area and another one up in probably northwest Georgia, just to kind of get a feel for what people have been going through with this post-litigation system that we have in Georgia. We got a lot of smart people here in the room, and really what we're looking for is ideas. This is a big task. The more I think about it, the more things keep cropping up that need to be dealt with when we do make the changes. And so if anybody has ideas about what they think we should be doing, please let us know. Think about being a legislator. A lot of people bring problems to you, but they don't bring solutions. So it would be helpful for anybody that has a good idea. So let's see. With that, do we have a sign-up list?
We do.
We do?
Oh, you got to introduce them.
Let me put my glasses on so I can see. All right, yeah, Judge Cynthia Adams from Douglas, and Ann Harris, everybody knows her. And David Amadia, soon-to-be judge, sitting over there, and I will call on you. No, I'm just kidding. Yeah, you do still have me. Yeah, okay. All right, so I guess to get started, then we need to, I guess, start the list, right?
Oh, yeah. Or you want
What? Well, we could do that. Chief, if there's anything you want to start us off with, you want to come to the microphone. I think your concurring opinion in the Sanders case spelled out what your thoughts were on this, but anything you want to say?
I do think that opinion, which I think y'all have in front of you, probably says a good chunk of my thoughts on this, and I'm not going to repeat those here. I will just say, anytime we think about changing an existing system, we're always going to have trade-offs that are in play. There is no way to make the system just better without also having some drawbacks. Those drawbacks are real, and I don't want to pretend that they're not. But the existing system that we have itself contains trade-offs that no one has ever actually sat down and said, are the trade-offs the existing system represents the right ones? Are the drawbacks of the existing system worth the existing system? And that's really the point that I was trying to raise in the concurrence, because I am skeptical that the problems of the existing system are problems that any of us would have chosen if we were presented with a question on a blank slate. We have backed into that system really over a period of decades, across a series of decisions from my court, each one of which has made sense in a silo, but when you put them all together has created a system that increasingly just doesn't work terribly well. So I'm happy to answer whatever questions y'all have, but I certainly don't want to take up any more time by monologuing.
Sure, yeah, and I want to thank you for bringing this to our attention. When I was DA back in the early 2000s, I had an experience with my counterpart in the public defender's office trying to handle an appeal that she had nothing to do with at the trial level, and nearly got disbarred for doing that. And so it's like you said, it's unintended consequences that come from some of these decisions, and that was one of them. And it chased her out of the position. She left, which I didn't blame her for what happened to her. But she thought she was doing the right thing, and it just the rules didn't work.
Yeah.
So I appreciate what you've in recognizing this and bringing it to our attention. So thank you.
Thank you.
Yes, sir.
Thank you, Chief, for being here. Thinking about this as a system, one of the suggestions in your opinion is to decouple the requirement that when individuals file a motion for a new trial, that they have to raise ineffective assistance of counsel at the same time.
Yes.
Can you help us think through, if we were to statutorily enact that to be decoupled, what would be some of the consequences of it? Because what we don't want to do is to create more problems, and it would be helpful for us to just have some understanding of these trade-offs that you mentioned.
Sure. So we held in a case called Garland in 2008 that this requirement to raise ineffectiveness on your motion for new trial, coupled with the rule of professional responsibilities application, which means a lawyer can't raise their own ineffectiveness, the combination of those two things means a criminal defendant, after convicted and sentenced, is entitled to a new lawyer who is conflict-free to litigate that motion for new trial. And that is a constitutional holding under the Sixth Amendment right to counsel. As the opinion points out, if there is no longer an obligation to raise that ineffectiveness claim on the motion for new trial, the constitutional holding in Garland likely becomes abrogated, such that that automatic right to to a new lawyer, a new conflict-free lawyer, for that direct appeal may no longer be effective, which has the effect, if a new lawyer is not provided, if you have a public defender, you're not going to be able to raise ineffectiveness realistically on your direct appeal. And so that's going to be deferred to habeas. The only way for that to work is if there is also created at least a modified right to counsel for initial habeas petitions. Not necessarily for all of them, but for at least ones that have the potential to contain meritorious claims. Because the U.S. Supreme Court, although the court has never held that the Sixth Amendment requires appointed counsel in habeas, if habeas is the first opportunity to raise ineffectiveness, they have held that the deference federal courts afford state judgments in criminal cases is not to be afforded if there's no right to counsel in that habeas proceeding. So I don't think any of us would want that. We don't want federal courts reviewing state judgments de novo. And so that the provision of some modified right to counsel in habeas becomes, I think, critically important at that point. The other piece that I think is important, there would be some benefit to adjusting habeas venue so that that first habeas petition in which ineffectiveness is litigated happens in the court of conviction rather than in just the superior court for whatever circuit the prison is in. That then, if you did it that way, perhaps by making the DA also in their official capacity a defendant in habeas actions, the DA would then have the option to defend that habeas petition if they want to, which I know in talking with some DAs is something that there is interest in. But by moving that venue, in addition to being closer to where the lawyers and the witnesses and everybody else other than the incarcerated defendant are, it also spreads the work across the state as opposed to concentrating all of those now much more involved habeas petitions in the handful of circuits that have prisons.
May I ask a follow-up?
Yes, sir.
Thank you for that, and I agree with the venue recommendation, and that makes a lot of sense. And with respect to the meritorious habeas petitions, I agree with you on that too. Do you have any guidance in terms of what might be done to identify those that would fall into that category versus those that would maybe not?
So I think in traditional fashion, you have put your thumb on the single hardest question in all of this. I think figuring out how that works, particularly when you're talking about habeas petitions typically being put together by pro se parties.
Yes.
That's I think the most critical piece to be solved. I don't have a genius answer to that today. What I do know is most states send IAC to habeas, and there's a lot of different ways that states around the country solve that right now. I'm sure some of those don't work terribly well, but surely something does, and surely there's a model out there that a study like this may be able to identify as containing some promise in that regard.
And if I can ask one last question to tie this all together. Those that are convicted, they have the rights of appeal, and there are certain timeframes and everything that apply to that. And then habeas they can file after their appeals are exhausted. And on that, is there anything else within the initial part of the appellate practice that we should look at besides what's already been identified in your current concurrence? Are there any other issues out there, if we're looking at this as a system in a whole, that we should really be paying attention to?
So I will say, I mean, my principal concern in this space is the extreme delays. And I will say another really substantial contributing factor to the delays that we're experiencing right now is the time that it takes to get a transcript from court reporters. That is a material contributor to the delays that we are facing now, and that is a real thing. You know, Judicial Council brought legislation over the last couple of years that y'all passed to allow for digital takedown in certain circumstances to free up the court reporters that we have to do transcripts, and that's still being phased in, and judges who want to use it are using it, and judges who aren't yet comfortable with it aren't. And I don't know how much of a benefit that's going to be, but anything we can do to shorten that period of time that it takes for that transcript to be created is something that can meaningfully move the needle. I don't have any silver bullets for that one either. There's a reason that we haven't solved it yet. It's hard, but that is a real problem. I will say, I do think in most cases, if we did move IAC to habeas, in most cases, you're not even going to need an evidentiary hearing for most motions for new trial. And so you're not going to need that second transcript the way that you need you're going to need a trial transcript, but you're not also waiting for a transcript on the motion for a new trial if there's not a hearing on that, which is a meaningful thing in the cases for which that would be possible. There still would be claims in some cases where you need an evidentiary hearing depending on the issues raised, but the vast majority of the appeals that I see don't contain those sorts of issues. The only issues where the record is developed are the ineffectiveness claims.
Okay, thank you.
This is kind of the reverse of when we come into your court here.
Turnabout is fair play.
Okay, I don't see anybody else with a question. I'm sorry, go ahead.
Mr. Chief Justice, thank you. Good to be in the capital city on a Friday afternoon. I wanted to just ask you real quick. Obviously, the most obvious suggestion is to move IAC to habeas. However, could we not also look at another scenario where we actually allow for a broader plain error review?
So I think there's a number of other things we can look at, and one thing would be expanding plain error to cover all claims within the criminal system, which is similar to how it's done in the federal system. Plain error right now applies to evidentiary rulings by statute. In the evidence code that y'all passed in 2011, it applied plain error to those. And then we have, just as a matter of decisional law, applied plain error to a tiny subset of additional things. But there's a lot of things where if not raised before the trial court, we then say are waived on appeal. That has never made a whole lot of sense to me. And I certainly would not oppose the extension of plain error to other things. I know that carries with it a range of other issues, but that's certainly something worth considering. I will tell you, in conversation with my friends at Gactyl, I think they'll probably stand here and tell you one thing we ought to consider, and I think it's an interesting idea, is creating essentially an office of the appellate defender. If you think about it right now, GPDC is responsible for providing indigent defendants lawyers both at trial and on appeal, but because of our conflicts rules, they are really hamstrung in providing that counsel on appeal. And if you had a separate entity, if you essentially bifurcated GPDC and said you're going to have the office of the trial defender and the office of the appellate defender, a lot of those conflict problems go away by doing that. I don't know what the price tag on that is, but if we're already providing separate lawyers on trial and appeal, I would think it just as a matter of logic, it shouldn't be that much.
The last budget request was $9 million
Well,
for conflict counsel.
I have many views that I probably shouldn't say on a televised committee hearing, Mr. Chairman.
No problem. I won't put you on the hook there. Do you have any other questions? Anybody else have one? Rob?
Thank you, Mr. Chairman. Thank you, Mr. Chief Justice. As the Chief Justice knows, there is that expression of, you should keep your mouth shut and make people wonder about your ignorance rather than opening your mouth and reveal, erasing all doubt. But sadly, my mother never beat that rule. I've had some legislative career of breaching it all the time. So I'm going to do it today because I don't do much in this space. So you have a direct appeal. If you are in a criminal trial defendant, you have a direct appeal from that. You can file a motion for new trial, and then you can appeal whatever error you contend was made by the court below. Mm-hmm. And that would go to whichever court would be the appropriate one. And then you also have a habeas type of appeal. Is the habeas appeal, is that a statutory creation or is it constitutional?
So it's both. The right to habeas corpus is preserved in the Constitution, but then in statute, 91440 and following creates the statutory process for how you go about litigating habeas. And there's two different types of habeas petitions. There's habeas, when we usually talk about habeas, we're talking about habeas that is seeking relief from a conviction in a state court of record. That's someone who is incarcerated and who is seeking relief from their conviction following an unsuccessful direct appeal.
So affording the right is constitutionally mandated. The exact process is not necessarily
The process is entirely statutory.
statutory. One could, I guess, claim that a process was so ill-conceived that it was not constitutional, but generally, the process is not constitutionally protected.
That's correct.
For the most part.
The existence of the right to habeas corpus is constitutionally guaranteed. The process for effectuating that is entirely statutory.
So we have some, I don't know if I would say discretion, but we have some room to maneuver.
You have a lot of leeway.
Okay. And do the things that I, as a defendant, do in my direct appeal impact my ability to raise issues at habeas level?
Under the way that the current statutory scheme is structured, yes. If you don't raise an issue in your if you do raise an issue in your direct appeal, that's then res judicata for your habeas petition. You can only raise a claim about that through the lens of ineffective assistance of appellate counsel. Essentially, you raised it the wrong way, you didn't argue it the right way. If you don't raise an issue on your direct appeal, you then have to show that ineffective assistance of appellate counsel was the reason you didn't raise it. And so you're essentially, at that point, for an IAC claim in habeas, you have to argue 2 levels of ineffectiveness. It was ineffective for my appellate counsel not to raise the ineffectiveness of my trial counsel. And because the deficiency prong of an ineffectiveness claim leaves a lot of room for judgment on the part of counsel, when you stack those 2 levels of judgment, it is very hard to prevail under the existing system. Something has to be really, really deficient in order to prevail that way.
And if I understand correctly, the point of your concurring opinion is we've created a system which devotes so much time and energy into raising the least likely type of claim to succeed.
That's correct.
Okay.
The most likely type of claim to succeed is preserved trial court error, because the state's burden at that point is to show that it was harmless. In IAC, on the other hand, it is the defendant's burden to show that it was harmful. And that's just a much harder standard to beat.
And so is I think the thing that's been confusing to me is, like, on the civil side, if I have a trial, I appeal and I lose, I can't later come back and try to argue again something new. I'm supposed to, I got to do it all at one time, or else I waive it. But the habeas level of review or appeal always seems to me it gives you sort of a second bite at raising something completely new.
So that's right. Now, the reason for that is civilly you don't have a right to counsel. And so, your Sixth Amendment right to counsel is a right to effective counsel. And if so, the reason it wasn't raised the first time is your Sixth Amendment right to effective counsel was violated because your counsel was deficient. That's why you're then able to raise it later. But
Raise any issue later
Yeah.
that they should have raised.
Yes.
Not just ineffectiveness, but anything.
Well, habeas is only available for constitutional claims.
Okay.
And so if it's just ordinary trial court error, you're not going to be able to raise that as in habeas, as a claim of ordinary trial court error. You have to raise it through the constitutional lens of ineffectiveness in order for it to be cognizable in habeas.
All right, that helps me kind of at least get my feet under me a little bit on this. I appreciate that.
Of course.
Chief, I appreciate, I told you that you weren't going to have to speak very long, but I do appreciate what the questions you've answered and what you've shared with us and your knowledge of this issue, so.
Well, I just very much appreciate you each devoting the time and attention to this issue. Thank you so much.
Yes, sir, thank you. Go to John, or who's next? All right. Well, I could just go down the list, and I think that's probably the safest way to do this. Veronica O'Grady?
Good afternoon, y'all. So my name is Veronica O'Grady. I've exclusively pretty much been practicing in the criminal realm my entire career. I clerked for a federal magistrate for the first year at a law school, and then after that worked at GPDC's appellate division for several years, then went to Clayton County, did appeals there, and then did trial work in Clayton County. Now I work at the Georgia Innocence Project, but I'm here in my individual capacity. I'm not talking about.
Could I get you to get that microphone a little closer to you?
Yes, I'm sorry.
Yeah.
So yeah, I'm not trying to represent the Georgia Innocence Project here. I'm just kind of talking more about my general experience, especially having worked in the public defender's office for so long. I know a lot of folks here today have probably great suggestions for how we could go about this or how this might impact other aspects. What I specifically wanted to talk about was the fact that it would be the impact on trial attorneys, which I know sounds weird because this is about post-conviction and appellate. But so the thing is that obviously, like with most governmental entities, right, if GPDC has no requirement to provide conflict-free counsel, they're not going to send out the appeal to the appellate division or contractors. It's basically going to stay in-house in that same local PD's office, right? And the thing is that the vast majority of local PD's offices have no appellate person, no dedicated person who has experience with or regularly does appeals. They frequently send them out to the appellate division. That's how that works. There's about 3 or 4 that like permanently have appellate people. I'm thinking Fulton, DeKalb, Savannah. Every once in a while, some of the other ones will have one, like someone who arrives at the PD's office really wants to do appeals, and then they'll do them there. But it's extraordinarily uncommon. So basically, if I'm, and again, I worked in Clayton County. When I was at Clayton County, I was assigned 582 human beings to represent. This was 2 years ago. And so if I have 500 clients, and then you're asked to do one appeal on top of that. So an appeal, of course, right, you're gonna have to read the record. Even if it was you're looking for your preserved error, right? So gonna have to read digest, which is, a specific way of taking notes, right? And then you're gonna need to do your legal research, of course, make sure you got all the good case law to support your positions, right? And again, we have plain error, so even if you miss something, there might well be things you could look into. You're like, oh, I did, in the heat of the moment, I missed that hearsay objection, right? And then you're gonna need to go visit the client in prison. And again, as we've talked about, the prisons are frequently quite far away, so it's usually gonna take a whole day. So we're really talking about, and again, I did appeals for quite a long time. So we're talking, even if it's just record, no investigation going on. We're talking about a good 18 to 22 business days of focusing just on that, just that. And so if you have a trial attorney who's going to trial once a month, which is probably about common for especially the larger jurisdictions, and you're in court 3 to 4 days a week, and when you're not in court, you're going to the jail, you're doing your visits, you're getting things ready, negotiating plea deals, that sort of thing. Trying to find, even just for one appeal, 18 to 22 days of I'm doing nothing but this would be almost impossible. Like, to be candid, I've done appeals for a long time in my career. If I was handed one appeal at Clayton County, I would quit. I'd be like, I'm not gonna do that. No, thank you. So I think it's kind of almost an impossible ask for an already overburdened public defender system, because there's not gonna be fewer appeals, right? It's just, so like they're still gonna have to do all of them. All of the ones that would, can't afford an attorney, they're still gonna stay. And so I just wanted to point out that, I foresee a bunch of people who are like further enough along in their career, confident enough, have built a good reputation, being like, instead of having to do something brand new that they have no training to do, don't know how to do this appeal, they can just be like, I'll just go open my own practice. And so I can foresee losing a lot of talented, established people who just aren't willing to do that. And that's kind of my worry.
We don't pay them enough anyway. Keep them, so, yeah. Any questions?
I have one.
Yes, sir.
What is your opinion of the potential for decoupling the requirement to file an ineffective assistance of counsel claim with the motion for a new trial? And how do you see that playing out in terms of the repercussions to the system?
I think it would, candidly, because the trial, like these local offices aren't prepared to handle all of this. I think it would collapse the system in a lot of places where there's not an appellate practice. For like Fulton County might well be fine because they have a number of great appellate attorneys already in their office. But like even DeKalb's got one now, one person for all of DeKalb. I don't think it would survive. I think it would create more problems on the back end, specifically at the trial court level. I mean, of course, there are other states that absolutely do reserve IAC for habeas. So I'm not saying that would necessarily be impossible to work. But I think the impact on trial levels without putting a bunch of things in place or getting some data, talking to some of these local PD offices, seeing what that would look like for them, it would just be a cascading effect that I think in 5 years you would see a real problem with courts even being able to move things, because without PDs, cases aren't going to move. So I think that's kind of my concern.
Do you think there's any merit to the notion that there could be greater efficiency, though? Because right now, the appellate claims can't be made by the trial counsel, recognizing that there's different skills between being a trial counsel and an appellate lawyer, but they have to, every time, get a new lawyer now. Whereas it seems to me there may be some efficiencies where that incidence declines if we were to make this change to have IAC with habeas.
I think the question is like, what efficiencies are we asking about? Because if we're asking about, like I said, if you're asking from me, a criminal defense attorney, no, it would not be more efficient. Because when I was at the appellate division, that's what I did. We got new appeals from the local office. I investigated it. We raised IAC quite frequently, and not frivolously, just ones that when we were talking to the attorney, we were like, I don't think you have a good reason for why you didn't do X, Y, Z. And I think legally you ought to have. And I think, I genuinely like the idea of a bifurcated GPDC handles trial. We have another office where you have staff whose only job it is to do this work and make those assessments. I think that would be very extraordinarily efficient. I think that's why a number of states do that, right? Because they are such wildly different skill sets. I guess I have a hard time seeing how moving to habeas would be more efficient than having an office that is entirely separate from GPDC, whose job it is to handle those. Those things seem to me equal, like, would it provide a lot of efficiency and moving things faster if we're worried about, who do we appoint? Well, if you have a whole office, there are plenty of people you could choose from to appoint to this case.
If we had that other agency or office and we decoupled, do you think that that would work?
I don't think if you're going to decouple, I don't know that yeah, I think, yes, it could work, yeah, because because like I said, the local people are not, it's not that they're not capable, it just would be too much to add in something so entirely different from what you do every day to add in this an appeal responsibility.
Mm-hmm.
So yes, I think that could, definitely wouldn't be impossible to have that number of states do that, I believe.
Okay, thank you.
Anybody else? Thank you very much.
Thank you.
Kristen Verrill, Georgia Innocence Project. And I may have mispronounced your name.
It's Verrill. It's
Verrill.
Verrill. Yeah, close enough. So I'm Kristen Verrill. I'm the Executive Director for the Georgia Innocence Project. And I just want to talk about, I don't want to repeat what's already been said, but I do want to talk about sort of planning for the significant resources that would be required for this kind of overhaul of the system that we currently have. If it's not done right, from the Georgia Innocence Project's perspective, we think this will result in more wrongful convictions. About a third of exonerations nationwide last year involved ineffective assistance of counsel. So the impact on wrongful convictions, if this system is not done right, could be significant in Georgia. So we really do want you to take into consideration overburdening the trial attorneys with appeals, not coming up with a system where we have sufficient resources to handle the workload of the new system. If public defenders don't have the capacity to do it, if it's moved to another agency, that's wonderful. But what we want to do is really ask this committee to slow down and really research the other jurisdictions that have done this successfully and what are the resources that they require to do it successfully and to maintain the system. So I actually would like to consider some of the interim solutions to create more efficiencies in our system. The trial transcripts taking an exorbitant amount of time. We've experienced that in our work. We also experienced delays with trial transcripts and the trial record being moved up to the appellate record, or to the appellate courts. These are two sort of interim steps that if we can figure out how to make an impact on that, would help speed up the system and give us time to create a broader change for the state in the system. So that's what we would suggest the committee also, if we're considering a bigger system overhaul, also consider these smaller interim steps that might move the needle faster and probably less costly. So.
You got one? Go ahead.
I have lots of questions. I think you and others know that I am very supportive of those who are wrongfully convicted, but I'm not sure that I understand the point that you were trying to make in terms of how this could potentially lead to more
Yeah.
people being wrongfully convicted, because that's at the trial level, whereas we're talking about the appellate and the post-conviction stages. So help me understand that direct nexus that you're
Yeah.
articulating.
So I'm talking about a scenario where the trial attorneys, the defense attorneys would also be responsible for the appeals because there's no right to a conflict-free attorney on your appeal.
Okay, so I think I understand, which is if we make the change and we don't have a separate agency that has expertise on the appellate side, that you would pose, but you'd be supportive of having experts potentially or appellate lawyers potentially take on this responsibility if there's a decoupling. So that seems to be a common theme that we're hearing.
Yes.
That we don't want the requirement for the appeals to be on the trial lawyers because those are different skill sets. Is that accurate?
Correct, yes, yes. And I do think in this scenario where there's another agency, the devil is kind of in the details, like who determines and how do you determine who is eligible for an attorney, an appointed attorney at habeas. There have been some studies in innocence work where the screening to determine whether you're entitled to an attorney is not effective, and innocence projects throughout the country have found ineffective assistance of counsel when the screening system did not find a viable claim and did not give them a court-appointed attorney at that stage. So I think that having a good system, workable system for deciding who gets an appointed attorney is critical to that sort of bifurcated system working.
In the habeas cases that you all work on, you all do a lot. What are the ones that are most successful? Are they typically IAC or are they something else?
Often it's both.
Okay.
We find constitutional violations, the Brady violations, or NAPU, and we also find ineffective assistance of counsel. But it's correct that we have to have two layers of effective assistance of counsel. Right?
Okay.
Yeah.
Thank you.
They're almost always combined.
You got one? Go ahead.
I think of all this, I mean, just appreciate all of our public defenders and the great work that the Innocence Project does. It seems to me that it is asking a private attorney to go back and review the record and find their own ineffectiveness, then, determining how you want to interpret the rules of professional conduct. I'm probably going to have to notify the malpractice carrier.
Right.
Potentially too. So I can see that although it seems like it would speed things up, be efficient, how many are going to actually own up to ineffectiveness? Do you see that being an issue that we could see a decrease in ineffective claims if
If it's the trial attorney trying to decide whether or not they've been ineffective, yeah, I do think so. And I think sometimes you just don't see it if you've been involved in the case, right?
Sure.
I can tell you, in my experience, I've had them get on the stand and say, oh, yeah, I screwed that up. I didn't.
Well, that does happen.
Yeah. I mean,
Possibly only after somebody else has looked at it.
and they
talked
do
to
it without consequence. Nothing happens to them. Anyway.
And as far as habeas, I want to touch on that. You have the 4-year statute of limitations here in the state. You have a 1 year for federal habeas.
Correct.
And so, in looking into this and looking at habeas as well, seems to me there may be an issue on the horizon here that we're incentivizing state, but a lot of defendants, especially indigent, they'll never be able to take advantage of the federal habeas because they have passed the statute. I mean, do you think that's an interplay here as part of the discussion we should have?
I think it's something that we should try to address, yeah.
Thank you.
Anyone else? think you're good. Thank you.
Okay, thanks.
If not, I'll call you back. And I hope I get this right. Anna Arsenault? Am I close? That's correct. Did I do?
Correct.
Oh, good. Okay. Georgia Resource Center.
Good afternoon, and thank you for the opportunity to address the committee today. My name is Anna Arsenault, and I'm the outgoing director of the Georgia Appellate Practice and Educational Resource Center. So if you hear from our office at the next convening, it will likely be from someone other than me. I'm going to another nonprofit organization. But I wanted to talk to you today to explain who we are, as some of you may have familiarity with us or you may not, and the role that we serve in the state. So our office was founded in 1988 in partnership with the state bar, the state legislature, the state and federal judiciary, and the Georgia State University College of Law to address the fact that people under sentence of death in habeas proceedings in Georgia do not have any right to representation. All of those entities, including yours, were very concerned with that cases could proceed to through habeas and ultimately an execution without counsel. And so our office was created to address that problem. And since the late 80s, we have been doing just that, either through direct representation. We have a staff of attorneys and investigators who handle cases in state habeas proceedings and subsequent proceedings. But we also recruit counsel to support our work because we're not fully funded at a level where we could do all of that on our own. So Chairman Gunter, you started the committee hearing with the observation that a lot of people come to the legislature with problems, and while there are many criticisms of the system and the way that the death penalty cases are handled in Georgia, I would actually say that this is not one of them. And so as the committee is considering changes to the habeas system in general, that like many other ways under the law, that you may consider doing death penalty cases differently. And I can talk about specific examples that already exist in the law that do just that, even in the habeas system. I wanted to note, in response to some of the questioning that others have had, that we raise frequent, so death penalty cases are different in that we do raise ineffective assistance of counsel claims for this first time in habeas proceedings, and the reason for that is structural. The Georgia Capitol Defender's Office now exists and has for several decades to handle death penalty cases at the trial level, and by statute, they continue on through the motion for new trial proceedings and through the direct appeal. So as we've heard, an office that has represented someone at trial can't then raise an ineffective assistance of counsel claim against themselves. And so in death penalty cases, unlike other cases in the state, IAC claims are raised for the first time in habeas as a general matter. And that's working, in my view and in our office's view, well. That makes a lot of sense to handle it that way. The Capitol Defender's Office and our office have specialized expertise in death penalty litigation, and so we're able and appropriately to handle those appeals and then our office in post-conviction in a way that it doesn't sound like non-capital cases are necessarily handled today. I did want to mention that the claims we raise are not frivolous. We, in the last 4 cases that have proceeded to an evidentiary hearing in the last several years, we have won 3 of the 4 of those on ineffective assistance of counsel claims in the Superior Court. Unfortunately, in my view, 2 of those were reversed on appeal by the Georgia Supreme Court, but these were claims that a Superior Court judge heard and decided that our client was entitled to relief. So these are very important and serious claims. We do raise a host of other constitutional claims, as Kristen was mentioning, with the Innocence Project, including prosecutorial misconduct. Those are kind of known as Brady claims, and juror misconduct claims, and we do have success on those claims as well. So I just wanted to highlight that difference in the structure of death penalty cases compared to other non-capital cases in Georgia. Another significant difference, and this may be something that you're aware of or not, but is that the judges in death penalty cases and habeas proceedings are assigned through a lottery system statewide through the Council of Superior Court Judges. So that is a very different process compared to non-capital cases. So when we're talking about potentially changing the venue of where habeas cases are heard, I would again urge the committee and the legislature as a whole to consider not making that change for death penalty cases, because the Butts County, so the men's death row, there's only one woman on death row in Georgia. The rest are in Jackson, Georgia, at the Georgia Diagnostic and Classification Prison. And that means that Butts County Superior Court handles all of the habeas cases that are heard in the state. And the Department of Corrections even created its own courtroom at the prison, so they weren't having to transport people under a sentence of death back and forth to the courthouse, although sometimes we do. Now that there's much fewer people on death row than there used to be, sometimes we do hear cases in the Butts County Courthouse. But in terms of transporting people, I think the Department of Corrections, obviously they can speak for themselves, but I think they would not be thrilled to be transporting death sentenced prisoners all across the state to have their habeas cases heard. And we do have many, many hearings leading up to a final evidentiary hearing in a death penalty case, as just another example of how death penalty cases are different than non-capital cases. And so, as I mentioned, under the code 91447.1, that is the provision of the appointment of judges that comes from all over the state. So we have a judge appointed in a death penalty case who may be from DeKalb, who's hearing the case in Butts County, or maybe from the Southern Circuit and hearing a case in Butts County. And I think I wasn't around when that was passed by the legislature, but I imagine that kind of spreads the workload of these very voluminous and complex cases across the judiciary, so it's not landing all on Butts County. So that is a major difference. So I think I'll leave it open to questions at this point, but I just would urge the committee, as you consider changes to the system, that there may be some changes that would not be appropriate in the death penalty context. And kind of, we aren't a problem that needs to be broken, in my view, at this time. Or the problem that needs to be fixed at this time.
I think you'll see better when we actually produce a product at the General Assembly, where you can tell us where we're going wrong. So you'll have plenty of opportunity for that, I think. Anybody have questions?
I do.
Yes, sir.
Okay. A couple questions. One is, how many people are facing death sentences right now?
So there's currently 33 people on death row.
How much money do we spend on this?
So we currently receive $900,000 from the legislature. We've asked for more. The House and the governor both were willing to pass additional funding for us, but we stalled at the Senate. So we'll be coming back next session for that. But that's about 70% of our office's entire budget, because we also represent people in federal habeas proceedings and then in clemency proceedings before the Georgia Board of Pardons and Paroles. So we have other sources of funding, including the Georgia Bar Foundation, which has been a very, very significant supporter of our work, especially in recent years.
Okay. And then in terms of the population of those who have been sentenced for, or have received a sentence of death, it's currently 33. Has that been fairly constant over the last decade, 2 decades? Has it declined? Has it increased? Can you give us any sense on that?
The death sentencing rate in Georgia has dropped precipitously in the last 2 decades, really. But when our case docket has not changed significantly because we often don't get the case until the case goes into state habeas, and sometimes the motion for new trial proceedings with the Capital Defender's Office can take many years. So we have cases that we just received for the first time that we're handling in habeas where the death sentence was imposed many years ago. But, we, relative to other states that have a state agency that does the work that we do, we represent a very significant cost savings to the state, even though that does seem like a low number of people, and it certainly is much lower than Georgia has had historically. But in contrast, I don't have the numbers in front of me, but the state of Mississippi has a similar number of people on death row and is funded at about $2 million a year by the state exclusively. So these cases are complex and voluminous and require very specialized understanding of the law. And so we do have many hearings and we do a lot of briefing. And so even though the number is lower, we do have a lot of work to do.
Understood, and it's certainly important work. My next question may be outside the scope of your expertise, focusing on death sentences, but we have a very, very large number of people who have life sentences without parole, which means that they're going to die in prison. So do you have any thoughts on what we're doing and how it impacts that population?
Yes, our office has actually started taking on, we had a fellow who's present here, Justin McCarroll, join our office through Equal Justice Works Fellowship to take on some life without parole cases in habeas. And we have some attorneys who are joining some of those cases as well, but it's not even scratching the surface, of course. But I think that is an issue that deserves a lot of attention from the legislature as well.
Do you have any sense of the idea of that population size?
Justin probably does, but I don't.
I think it's
You-
tens of thousands, right?
Do you want to say?
I'm getting
But it grows, it's growing at a pretty massive rate. I think it's 3,000. Off the top of my head, I think it's about 3,000.
3,000? Okay, that's a lot less.
And it increases roughly 200 to 300 people per year, Georgia's prison population.
Okay, thank you.
You got one?
What's the average caseload that you carry per year, or year in, year out? I
Average
know it's a little
caseload?
different for y'all, but
Well, we take responsibility for all of the people on death row. Some of them, as I mentioned, aren't quite yet our clients, but I think that's only 2 or 3 at this point. So we're either directly representing everybody else or we're supporting attorneys who do. And the main other entity that provides representation to people on death row in Georgia is the Federal Defender's Office for the Northern District of Georgia. So once a case is in federal court, they'll be handling those cases, but we still provide extensive support to those teams as well.
so how many cases are you lead attorney on per se, or do?
That's a good question because I've been trying to withdraw from all those cases right now, maybe 20 or so. But I have the highest caseload in the office, so I try to keep our staff attorneys at 4 to 6 each. And that's very similar to the Capital Defenders, if not more than the Capital Defender's Office.
Do you think that's a comfortable caseload, considering?
I do, but the problem that we have, and I know this isn't about us today, but when we have turnover, that really impacts what we're able to do. So you have a new person that then has to learn tens of thousands of pages of the case and get up to speed on a case that may have been going on for decades. So in theory, it's a manageable number, but when you start at our office, it's very overwhelming. And because of salaries and all the things that the system faces generally, we do have more turnover than I would like.
What's the average salary? Or let's say starting salary?
Our starting for a new entry-level attorney would be about in the high 70s, which is, I think, consistent with the Public Defender Council.
That's all the questions. Thank you.
Thank you.
All right. Gackel, Maisie, or whoever? Okay.
Thank you so much for having us come, Chairman and Commission. I'm Maisie Lynn Girton, the Executive Director of the Georgia Association of Criminal Defense Lawyers. Having never done appellate work myself, I'm joined by our President, Aaron Gersensang, who will be serving throughout this year and has been a lead shepherd on our conversations around this issue ever since the Sanders decision came out. And then we've also brought some practitioners who, two in particular. One is Lauren Shubo, who has been a state appellate attorney, and then Leanne Webster, who's got a lot of experience in federal appellate cases. So Aaron will start us off, and to the extent that it's helpful to hear from Lauren and Leanne, you can. And we've also provided your commission with a one-page sheet that just gives you an overview of the appellate process in Georgia. As I mentioned, I'm not an appellate lawyer, so it was educational to me to review that. I hope it'll be helpful to you all as well. We brought plenty enough if any of the other members, if people here would like some. I think I brought about 30. And on the back of that, for your reference as well, we've had some of the experts within our membership who handle appeals. Some of them you've heard from today, there's a lot of overlap here between GACTL membership and some of the other defense agencies in town. And I know it's very small, so I'm gonna send you the soft copy as well, so that, like me, you can hit that plus sign on your Adobe. I have readers too. I'm looking at you, Chairman Crow. But in all seriousness, those are some of the leading experts on handling appeals from a defense perspective that we've provided you on the back, and they're all very willing to take individual calls that you might have, or questions that you have that don't come up today that maybe come up over time as you pursue these conversations. So I will turn it over to Erin.
Thank you, Maisie Lynn. She said, I'm Erin Gersten-Zhang, and while I am the president of GACTL for the last 21 years of my criminal defense practice, I do not intersect with appellate work. So I, like maybe some people in the room, have gotten to get a crash course over the last 4 or 5 months to learn about what this proposal would look like and what our community as a whole might love about this proposal and might have concerns about. And I think, as Maisie Lynn mentioned, one of the ways that GACTL hopes to show up in this process is as a resource. We have had many hours of meetings. Collectively, there's probably been over 100 hours of work, volunteers from our organization and also other organizations that have gotten together to workshop what this could look like. And we really appreciate a bunch of the leaders in the room here meeting with us in advance to talk about some of these issues, because as a criminal defense community, we don't always get the opportunity to have so many leaders in Georgia sitting around thinking about how we can improve the appellate system. And for that opportunity, we are so grateful. As we've been thinking through these issues, one of the fears that come up, and because we don't have a proposal to look through, we don't have specific notes to provide, but one of the themes that has come up over and over again is a concern that there are ways to do this that would further deepen the divide or entrench the indigent defense in a way that does a disservice to the courts and the criminal justice system in Georgia. And so one of the things that we have been looking and thinking about and workshopping is how do we protect the integrity of the system while looking for opportunities to improve efficiency and hopefully the quality of representation. So to that end, we love many things about the federal system and how the federal system uses and approaches IAC claims. But what has come up in conversations is it's hard to look at those proposals without understanding the infrastructure that supports an IAC claim at habeas in the federal system and how those things differ when it comes to what Georgia has. And so it's not a question, it's like a Jenga piece. You can't just pull it out without anticipating those collateral consequences. And so when we look at the federal system, not only have we been looking at how they handle those IAC claims, but what are the pieces that support that? And the Chief Justice already raised one of those #1 issues of transcripts. When we talk to appellate lawyers and they think about where is a big chunk of these delays coming from, transcripts are a big deal. in Fulton County, on average, you're going to wait 2 years to get a trial transcript to be produced. And that's not across Georgia. What's nice is actually the Supreme Court, I only found this recently, so we haven't been able to really crunch all the numbers, but the Supreme Court's website holds a lot of data about what pending motions for new trial, where they are in the process, how long did it take for transcripts, and everybody can look up their own county and see, and what we saw when we looked is not all of the counties suffer from those same kinds of delays, but we do know that in some of the more dense counties, that can be a considerable problem. Another thing that was raised already was this workload question. When we look at the federal system, one of the things that supports IAC later on is workload. One of the members of our executive committee, who's a federal defender, says, well, on average, our office here has we have about 20 to 30, they handle their own appeals, but they have about 20 to 30 open cases and 1 to 2 appeals per lawyer. And as we all know, we heard 500 open cases. I see Veronica nodding her head. 500 open cases on top of 1 appeal. That is difficult to imagine how we make that work in Georgia when we don't have that foundation to look at. I really appreciated Chairman Smith's question about plain error, because that's another foundational piece in the federal system. The federal system, you don't have to wait for IAC claims to raise a lot of errors that can make a huge difference for somebody's outcome in their case. They can raise those issues based on the record. They don't have to wait for a motion for new trial to subpoena the attorney and ask them questions about why they did or didn't object and get a response, well, that was strategic, or no, I made a mistake. They can just look at the record and say, this never should have happened in the trial, and it violated the rights by just looking at that record and not having to go through that extra process, which I believe is one of the places when IAC became the focus of a solution here. It's that shuffling around in that trial court level of having those hearings that will create that delay. So what we've done as part of these workshops, and we've produced a lot of pages of documents that we're not trying to dump on you all at once, but what we're hoping to be is a resource as you think about putting a design on paper and have questions. What questions do you want our help to answer? One of the people who has been working with us started a 50-state survey because we didn't know the answers to, well, how are other states dealing with this? And we've had that coming in. I think we have about 20 to 30 of the states responsive. We have some notes. But we've asked those questions ourselves within our community, but we would love to hear about the questions you care about and looking at what other states are doing, or what data should we mine? Because I think it's since 2019, that data about what's happening in the counties in Georgia. Is that right?
We passed that rule in
2018, yeah. So I think the data is current in 2019. What do you guys want to know about what's happening in counties around the state, and maybe which counties we should look at and compile and assist you in that information gathering? Because our position is sort of a yes and. We would love to improve these delays. We would love to bring more fairness and better representation to Georgia. And that just speaks to our hearts, absolutely. But we are also cautious because we want to make sure that we're preserving the integrity of our indigent defense process along the way. And I will take any questions, but if they're granular, I might have to phone a friend and invite Lauren to come up to answer some of the more practice-specific questions.
Okay, Scott?
Thank you, Mr. Chairman. One question that I have, since we were encouraged by the Chief Justice to think beyond just the immediate issue in front of us, is, I'd like to get your thoughts on this. My sense is that some of our underlying statutes really need to be looked at in terms of the criminal offenses themselves. Felony murder, one could be convicted of murder without killing anybody, but in the process of a felony, and there's different gradations of what that can look like. The armed robbery statute is a mess. It treats individuals that use a firearm that is loaded and lethal the same as it treats a replica or the classic putting your finger in a jacket and making somebody think that you have. And then there's very long sentences with that. Aggravated assault statute, there's others. So do you have any comments on that, of maybe Georgia can benefit from looking at some of our crimes that are on the statutes and maybe revising them as part of this overall?
I think I'm going to hand it over, but I think generally you put your finger on, when we deal with clients and families, those are exactly those kinds of circumstances that Georgians feel are very unfair. They don't understand that you could be convicted of felony murder because you were doing something otherwise maybe criminal but seemingly innocuous, and now you're facing dramatically different charges. So I think
Life without parole.
that's exactly right. So I think you're asking the right question. I'll bet at least a lot of the faces over here, if you ask them to raise their hand, if you want to relook at the felony murder statute, there's a lot of people who would agree. So I think that that's exactly the right question to be asking. Lauren?
It's just music to my ears that someone is thinking about this that's not in Gactyl, because, I mean, I do appeals full-time, and I can tell you, you're asking about life and life without sentences. I'd say 75% of my clients have life or life without. And a lot of them have done things that one would not think deserve those sentences, including a client of mine who stole $120 in a crack house from someone and got a life without parole sentence because of a finger in the pocket. I can give you so many examples of things like that that have happened, and the way that the Georgia system works. That would be a huge step forward. I don't know if it's directly responsive to what we're here today about, but if you are interested in that,
I am.
you have an entire group. I mean, we're not even talking just about the appellate lawyers. You can have hundreds of criminal defense attorneys and maybe lots of people lining up to talk about degrees of murder, talking about what felony murder means, talking about how aggravated assault can be a predicate to felony murder, which most places it cannot, because basically every assault that then ends in death is a murder in Georgia, as opposed to an intentional, malicious, pre-thought-out act. Again, I can go into lots of examples, but a one-punch case where you're with someone and you punch them and they fall down and hit their head and die, that could be a life without parole sentence in Georgia. And not to say that it's a good behavior, right? It's just meeting the moment of proportionate sentences for the types of crimes. So I think the number was 3,000 to 4,000, or 3,000 to 4,000 LWOP sentences. But if you include life sentences with that, it has to be over 10,000, maybe significantly more than that. And I can tell you that clients, we're still in the timeline where parole was eligible in 7 years, right? And none of them are getting out. The parole attorneys, I'm sure, can tell you, but the 7-year people, where they were allowed to be released after 7 years, are 35, 40 years in and still not getting out. And so even when we call it a life sentence as opposed to a life without sentence, in many cases it is functionally a life without sentence, or they're finally let out when they are so chronically ill that the Georgia prison system doesn't want to pay for them anymore. And so almost that. And so, I mean, we would love steps forward towards reforming some of the criminal justice statutes. And I think there's a lot of meeting of the minds in that, especially with how much we pay for prisons. I don't have the statistics with me, but I think Georgia has almost the most probationers as any state in the union, and more prisoners per capita than I think any state. Yes, I'm getting heads nodded, which we're not more violent or crimey than any other state, and yet we have those kinds of systems in place.
Grimy is a good word.
Go
On the
ahead.
transcript thing, Mr. Chairman, if I may, I do want to drill down on that just a little bit more, because we've heard that many times.
Yes.
2 years, let's say that you did have a valid basis for an appeal, is you're sitting there for 2 years before you can even raise it
Yes.
to get the transcript, which is unacceptable. Is that just a resources thing? Is it
Yes.
both the people and the money, or is it both? Like, do we have people that can do the work, or do we need more?
So it's people, it's money, and it's attention. I've heard the saying that every judge thinks the transcript wait is horrible, but their court reporter is awesome. So assuming that's true, they can't all be awesome, because then we all have to wait. And a lot of judges will keep their court reporter, which is completely makes sense, in the courtroom transcribing what's happening in the courtroom every day, and then they don't have the time to then go back and make the transcripts. I was told by a court reporter that every day of trial takes a day of work to do the transcript, okay? So if you only have half a day or 1 day a week to then go and create transcripts, that's obviously a problem. So we suggested in large places that have a lot of trials, having 2 court reporters in a courtroom so they can switch off more. We've also suggested in the federal system, you can get like daily court reporting, which I've never heard of in the state system at all. The idea that you see on TV that someone can like read back the testimony, that does not exist. And so the ability to have more court reporters. And then there are just court reporters that aren't doing their job. I won't name names or anything, but there are. And in the federal system, your pay gets decreased if you don't present and do things timely. We have copies of orders where if you don't do your transcript within, and now we're talking like 90 days, right? If you don't do your transcript within 90 days, you lose 10% of your fee. And so they have the incentive to do them more quickly. But transcript delay is huge. I spent all of my career up till 10 months ago in Fulton County as a Fulton County public defender in the appellate section there. It is heartbreaking to talk to people about that. I have a case where my client spent 5 years in prison on a case that was reversed by the Supreme Court on insufficiency of the evidence. So between the delay in getting the transcript, in getting an attorney appointed, in the clerk sending the record, and the courts deciding, it was 5 full years, and he was legally innocent. And that's just from my personal experience, so.
One more question, if I may, on the cost of the transcripts, and the state pays that, and then the defendant gets a copy and his or her lawyer does too? Like, how does that work?
So it used to be when we got paper, right? We used to get paper transcripts. I would walk around with binders this big. There's one copy, you get one free copy. Now, we don't get paper, we get electronic versions. So what I would do for my client is I put it on a thumb drive and someone else can print it for them. But we don't get paper anymore, so it's just available. But yes, the Constitution says there's cases that all indigent defendants get one free transcript. Our statutes also put the burden on the state to provide the transcript. They don't have to pay for it necessarily, but they have to provide it. And one of the things that no one wants to do except criminal defense lawyers is say, if you don't provide a transcript, the state of Georgia, by a certain period of time, then you just get a new trial because you're not providing a right to appeal. Because it gets to the point, I can't remember the statute off the top of my head. There's a statute that specifically says that it's the state's burden to provide that. And there are cases that have been overturned just for a lost transcript. I've had one, other people have had one, because you have to have an actual right to an appeal, and without a transcript, you cannot actually go forward with an appeal.
Okay, so the lawyers get a digital copy, which I understand, and I think all of us that are practicing are familiar with that. What capability do the inmates have? Do they have computers? Do they have emails? Or do they have to get paper?
Yeah, they have to get paper. So at the end of it, so just my personal practice is if a client tells me, I'm really concerned about witness X on direct appeal, I'll print up witness X for them and send them to them. But at the end of the case, if we've lost, which I think the statute, I think the statistics are like 95% of direct appeals lose, some 90 to 95. At the end of it, I have to print everything and send it to them. And this creates a real problem if we're moving habeas and they don't get lawyers, on habeas, because so much of the evidence now is electronic and they have no way to access it. So you're asking pro se people to be making these decisions and making the arguments about things, and they don't have access to any of it. So they'll get a paper copy of the transcript that I print out for them, and they'll get the paper discovery, like police reports, some of which I have to redact because it's a client getting them in custody, which is also problematic because then if they want to subpoena those people, how are they going to do it if I've redacted the information from them, if they're pro se? And they don't get, everything's on video now. Everything, and you have to be able to look at it and see it. Jail calls. I don't know how, jail calls are, for those who don't know, they record every conversation that you have in the jail. And lots of cases turn on my clients saying stupid things, okay? And some of those stupid things have a very innocent explanation, and some of them do not. But without the client hearing it and being able to give me that explanation, I'm just at a complete loss. And without them having access to them, which they wouldn't unless you, again, increase some kind of Georgia Department of Corrections ability to give everyone access to computers and law libraries and everything else. I don't know how you get to that point.
Go ahead.
So you've actually practiced at the trial and appellate level, correct?
Yes, the first 4 or 5 years, I did trial work, and then I moved to appellate work. I'm a much better appellate attorney than I was a trial attorney. That's not, we all have our own skill set.
Well, I'm sure you're great at both. My question is this, just getting back to kind of the guardrails of what we set out to do. Would it be your recommendation that we make the fix for IAC claims and allow those to be heard at habeas?
No, that,
And why not?
okay, so if I had a magic wand, okay, that I would create a state appellate defender office, a state appellate defender office that is separate from GPDC right now. We had a state appellate defender office under GPDC. And one of the things that I have the ability to do, because I no longer work for GPDC for the first time, is be able to tell you that the GPDC defunded that. And they defunded that over the legislature specifically saying, here's more money for it. And there were amazing attorneys in that office, some of whom are some of the most high-priced attorneys across the state right now, some of them in the room, some of them were able to do that work. And that was dismantled. And that was the backstop. I would always tell my clients that having an appellate attorney from that office or from my office, I worked in Fulton County, they're just as good as any private lawyer you could ever get. That is not the case now. It is sad. And some of the footnotes you can read and some of the opinions that have come out about the quality of representation that GPDC is giving appellate defendants is shocking. And so, and those are the people that GPDC hires either as contract workers or in their main office to do this. If we had a system that couldn't be messed up by the whims of the changing administration of GPDC that was separate, that is something that the courts and a neutral body could do a little bit more control over, you wouldn't have that. You would be able to have appellate specialists. Believe me, I can tell you from my own experience, my 93-year-old mother-in-law, who's very church-going, says that public defense is my calling. I don't do it full-time now because I couldn't keep doing that in that system. But I would go back tomorrow if there was an actual system that I felt was protecting clients' rights. And it's just not happening. And so I think the two things that stick out to me in the Sanders opinion, or in concurrence, is the delay and the quality of representation. And there are fixes for both of those things that don't involve a wholesale change to move things to habeas. And I think at least as a stopgap, trying to do those fixes might be a much better place to start than doing a complete wholesale overload of the system, because the idea of providing habeas defendants counsel, which I think is, as the chief said, is required on some level, what level it is, you have to create an infrastructure anyway to do that. And so when you're creating an infrastructure for a separate state appellate defender would allow that to happen. And I also think plain error review, expanding it is huge, and it would maybe move things a lot faster. I have to, for the attorneys the committee members who don't do IAC, one of the things that I have to do is, if the state did something wrong, or the judge did something wrong, and the defense attorney didn't stand up and say exactly the right words at exactly the right moment, I can't say it was the state that did something wrong or the judge did something wrong. I have to raise it through IAC that it wasn't objected to at that moment, right? And so everything has to go through one frame. If there were more frames out there, then we wouldn't have to have all of this IAC litigation.
That it? Anything else? Thank you.
Thank you.
John Melvin?
Mr. Chairman, Mr. Chief Justice, thank you for bringing attention. I am a prosecutor of 31 years, except for a 4-year detour down at the Georgia Bureau of Investigations. Started my career where we not only handled the trial, but we handled the appeals and have stayed hand in hand with the appellate practices going on. Thank y'all. I would like to offer a solution and ask that y'all consider the federal model. In the federal model, the statute is 28 U.S.C. 2255. And instead of moving the bottleneck that would happen by just decoupling and sending it to habeas, it actually changes the process. And the biggest difference between the model that we have and the federal model is, as of now, and the Supreme Court rightly says, raise your claims, because that emphasizes finality, emphasizes a complete appellate record. And it's beneficial to do it closer to the time of trial for the victims, for the defendants, and for counsel on both sides. Benefits. However, if we could decouple it and do the federal system, it'll have a significant benefit on judicial economy. Here's how it works in the federal system. Under 2255, 28 U.S.C. 2255, all legal errors are handled on the direct appeal itself, and the attorney of record could continue to stay on that. However, they can't raise their own ineffective assistance to counsel. 2255 puts it in a habeas proceeding, and what happens at that point is where the feds in Georgia significantly diverge. Under the federal system, a judge would look at the factual allegations of the petition and say, if these allegations are true, because everybody handles the Strickland standards. And they say, if these factual allegations are true, have they proved a constitutional claim? And if the answer to that question is yes, then and only then do we move to an evidentiary hearing. Because the way it's going right now is that when they're raising, when defense counsel and appellate counsel is raising ineffective assistance of counsel at the motion for new trial, effectively what is happening is that we are having habeas hearings in the motion for new trial. We are having full-blown evidentiary hearings. By following the federal model, we can decouple, we can kind of get away from that and have evidentiary hearings on these critical issues at the appropriate time. So federally, you have your appeal, your direct appeal on the legal issues, and the ineffective assistance of counsel will go forward on the habeas portion of it. When it is raised on the habeas portion of it, it is sent, and this goes back to, we don't want to just send them to South Georgia or whoever else has a state prison system. It is sent back to the district court that handled the case. And the district court that handled the case, like I said, asked that question. Have they proven a standard if the factual allegations are correct? And if they are, then they have an evidentiary hearing. If the judge says, no, they have not, Then what happens is that appellate counsel can apply for a certificate of appealability, and the decisions of the trial court are reviewed under an abuse of discretion standard. All the other standards are significant, are the same as pretty much George's motion for new trial. But that's the big difference. And it would promote judicial efficiency, because our friends on the defense counsel, they have to raise it at the earliest possible moment. In talking about this section in 2003, the United States Supreme Court had a case called Massaro, and even in that unanimous decision, they recognized that in the early stages, a trial transcript can't fully develop the record of whether or not an ineffective assistance to counsel takes place. And we know that's the case in Georgia too. I mean, and so they said that's why you're going to be able to have time to raise it in the habeas proceedings. And so if we go to this model, we'll produce judicial efficiency, and we'll do the screening process that is kind of desperately needed, because not every IAC claim, and I think if we're going to be honest, everybody will admit, if you have to raise it to protect your rights, then you're just going to do the kitchen sink, and the meritorious claims are lost in the noise. And we don't want those lost in noise. Prosecutors don't want it lost in noise. Judges, nobody wants to convict innocent people or have incompetent counsel be the reason somebody goes to prison. So I think if we follow the federal model, that it offers something to us so that we can, under the wisdom of Solomon, split the baby in half, but honestly get a more efficient system and allow the judges to be the ones that are kind of the guardian at the gates as we go forward. And that's what I had to say, Chairman Governor.
All right. Questions, anyone? Scott, you got one?
I have one. Thank you, Mr. Chairman. In the federal system, you said that the attorney record stays the same, so that's the efficiency. So the trial counsel are doing both the trials and the appeals? Did I hear you correctly on that?
If I said that and misspoke,
Okay.
what stays the same is the trial court. It is sent back to the trial court. So if Georgia follows that, instead of being tried in the county where the prisoner is residing, it'll go to the trial court that actually tried the case, or the trial division that actually tried the case. And that's what I meant to say. If I didn't say that, I apologize.
Okay. Thank you.
Yes, sir.
Sure, sir.
Thank you for your testimony. Just one or two questions, again, to kind of help give me some remedial training here and how this is done. So I understand from what you said, in the federal system, when the habeas petition is filed, it's almost assessed under what sounded like a civil motion to dismiss standard. If there's no circumstances from which they'd be entitled to relief, it gets dismissed. And here in the habeas, it sounds like only if the facts alleged, if assumed to be true, are assumed to be true, have they stated a constitutional claim. So, and that would determine whether the petition just gets dismissed outright or can proceed to a later, subsequent stage of review.
If the trial court determines that the facts as alleged would establish a constitutional claim, then you go to an evidentiary hearing, and the standards of review would be the same as the standard of review in Georgia. If the trial court says, no, they don't, then then the attorney representing the defendant could apply for a certificate of appealability, appeal, and then that would be reviewed under abuse of discretion standards, sir.
So, but that's just basically an appeal from that trial court to.
It is, but the standards are different.
Okay. So in the state system, is there also an evidentiary hearing on most habeas petitions?
Yes, sir, but they're also now, because they have to be raised at the earliest possible time, they're taking place really in the motions for new trial. And so what's developed, as the Chief Judge has acknowledged in the Sanders opinion, is we're having a very inefficient system where we're having full-blown evidentiary hearings. But if we could limit.
Twice?
I'm so sorry, sir.
Yeah, twice?
Yes, sir.
Like once in the direct appeal and once also at a habeas level?
Theoretically, that can happen, yes, sir.
Does that, to your knowledge, is that customarily what we're doing?
I do know that we are seeing ineffective assistance of counsel with almost every single appeal now. It's to the point that we're keeping.
With every
track.
direct appeal?
Yes, sir.
Okay.
Yes, sir. And motions for new trial, sir.
Okay.
So it's that, and so what's happening is at the motion for new trial stage, instead of dealing with the legal issues, we're having to have full-blown miniature trials yet again.
Focused on ineffective assistance?
Yes, sir.
Okay. So, and then a habeas case tends to involve,
Constitutional issues, yes, sir.
but it also involves, I'm just thinking procedurally, it's hearings all over again. It's not just sort of an argument as on appeal to an appellate court where it's off a record. There's an additional record to be created in the habeas court?
Yes, sir, in a different hearing. For example, if a person that I convicted 4 years ago filed a habeas and they're down in the prison down in Waycross, they would have the hearing down in Waycross by an attorney general, and the attorney general does a great job, but he's not nearly as invested in the case, or she is not nearly as invested in the case as I was as trial counsel. It's a cold record. It's years after the fact. Witness testimony is challenged at that time. And there's a lot of reasons not to do it at that particular juncture, to do it back in the venue of choice. But really, the answer is not the venue of choice. What I'm really proposing is that we let the trial courts be the guardian, the initial guardian, to be the gatekeeper on those truly constitutional cases that need to have a full-blown evidentiary hearing.
So are you, and I appreciate those thoughts. So are you agreeing that my understanding now is venue for a habeas petition is the jurisdiction where you're detained, where you're in prison?
Yes, sir.
And so that tends to overload the places that have larger prisons. I think maybe the Chief Justice and others suggested we might want to change the venue for the habeas petition to be that you file it, I guess, in the court where your conviction was rendered. Is that one thing you're suggesting also?
Yes, sir. Change the venue to the county where the conviction arose from.
Okay. And then are you also suggesting that we adopt a standard, I guess I would call a standard review at the habeas trial level that's more resembles the federal standard?
Yes, sir. 28 U.S.C. 2255.
Okay. And did you indicate in the federal system, the same attorney who handles the trial also handles the habeas appeal usually?
That's not in 2255, sir. Theoretically, I guess it could happen, but in 2255, it's dealing with the habeas petitions in federal court where they can challenge a conviction, and it does not limit it to the trial attorney, but it doesn't exclude the trial attorney.
Okay, all right. All right, thank you.
Yes, sir.
Any other questions? I think we're done. Thank you, sir.
Thank you, Chairman. Thank you, Mr.
All right, and we have the prosecutors here. Robert, you want to say anything?
Good afternoon. I'm Robert Smith with the Prosecuting Attorney's Council. I'm a little bit of a different breed of person because I've handled appeals and I've handled trial cases. In fact, I worked in a circuit where we did not have an appellate division. I was the appellate division. I handled 25% of all the criminal cases that were indicted in Fayette County, and then for the other 4 counties in the Griffin Circuit, I was the appellate attorney. So that's one thing to remember, is that we are very fortunate that some of the larger circuits that don't have public defenders, because remember, we do have some opt-out circuits, but those larger counties are the beneficiaries of very generous county funding to give them specialized units. But if we go outside of the metro areas, we end up in places where you clean what you kill, for lack of a better definition and better expression. You try the case, you handle the appeal. And that's not just the ones where they're represented by the public defenders, but it's also the ones represented by private counsel. So don't lose sight of that fact. I understand the need to do something. I've read the opinion and understand that there is a problem. I'm currently handling a 12-year-old murder and armed robbery case out of Columbus. It's 12 years old because in one of my 3 co-defendants, I'm on my 7th defense attorney. Every time somebody new comes in, hey, we got to raise ineffective assistance of everybody who came previously. 2 of the 3 trial attorneys are dead and can't testify because it has taken so long. The victims, something that you and the people of the state of Georgia tell me is a very important right, the rights of victims to be heard and to participate. 2 of my victims' families have said, please do not contact us anymore. We're tired. So we too, as prosecutors, have a vested interest in making sure this process is efficient, protects rights, and leads to finality. I understand moving habeas because there is a good argument to be made. And one of the things I'm looking around the room, I don't see our cousins from the Attorney General's office here. And they are a very important key part of this discussion. But remember, they only file, they handle the habeas for those that are incarcerated. They file direct appeals on murder cases to the Supreme Court. All the other appeals are handled by the 51 district attorneys and their staff in felony cases. If we move the venue, one of the things to consider is, as you know, each year you get confronted with a bill asking for an additional Superior Court judge in certain circuits based on a formula, based on a need. Several of those circuits, that formula is based on the number of habeas cases that come through the door. The clerks of those courts have additional staff designed solely to handle the prison litigation that comes out. So they too may have an interest or may have a discussion point they want to talk to you about, because by moving those cases and putting them into a circuit that hardly ever hears a habeas case, you suddenly may have to reallocate resources. You also may have to deal with, say, a very busy court. And I don't want to call one specific, but just think about, several of you are practicing lawyers. You know how busy those civil days are. We're about to add, if we move the venue, we're about to add civil cases onto that hearing day. And as Mr. Melvin pointed out, they could be evident, and also as my friends across the way have pointed out, these could be evidentiary hearings. These are not going to be one witness hearings. They're going to be additional, bringing out all the evidence. If you suddenly have a new expert witness to cast doubt into the experts that testified at trial, bringing back the trial attorney, bringing back the trial counsel who may or may not have made an error. We looked at 92 cases since January 1st that have been filed and decided by our Court of Appeals and our Supreme Court that raised ineffective assistance of counsel. 92 this year since January. Of the 92, 2 were reversed because of ineffective assistance of counsel. There were 2 others where the claims were barred because of a procedure issue. But essentially 4 out of 92 cases where ineffective assistance was found. That's a number, and I think that's just some significance to think about, because as was stated, what happens when you have a trial right now? You get a conviction because of the decision of Garland, which says that if an ineffective assistance counsel has to be raised immediately, you end up with the trial attorney stepping aside. And if it's the public defender's office, because of the formal advisory opinion 10-1, the entire public defender's office is out. So for those 45 circuits that have a public defender's office, they're out completely. You have to bring in a private attorney to handle it, a conflict attorney paid by the state. You don't have that appellate team that they were talking about. And that may be a very good idea to consider revising that. If nothing else, it builds in a certain level of fairness because, after all, as I mentioned, we do have the Attorney General's office that handles all of our habeases. And all of our habeases involving incarcerated people. Let me make sure I say that correctly. But when you bring in that conflict defense attorney, they are going to raise ineffective assistance. And right now it becomes a new trial, a completely new trial in front of the same judge or maybe a different judge, but it's in front of the judge. All of the evidence arguments are revisited. Everything is viewed from the lens of ineffective assistance of counsel, on top of any other legal issues. Hey, Judge, you didn't grant the motion to suppress, and you should have. hey, Judge, the law has changed now, and we need to have this level of hearing, and we should have considered this factor. But, oh yeah, also, don't forget, for the following 7 to 15 reasons, trial counsel was ineffective. They didn't ask for a continuance like they should have, or they did ask for a continuance and they didn't get it granted. They didn't ask these questions, and the Supreme Court and Court of Appeals have been very good about making sure everyone understands that there is a lot of strategic decisions that are made that are beyond review. But just because they're beyond review doesn't mean they aren't getting raised. So we end up with a new trial conducted, and I get into fights with my friends across the way all the time. But one of the things that happens when ineffective assistance of counsel is raised, that is a waiver of the attorney-client privilege. So suddenly we, and I encourage this, much to the horror and angst of others, I encourage prosecutors, you need to be able to look at that file. If the defendant is claiming now that I told my lawyer about an alibi witness, they didn't claim that alibi witness, and that's why I got convicted. Okay, I need to see your trial counsel's notes. I need to see if they wrote in, hey, I got told about this witness, but I'm not going to call this witness intentionally. Or, I got told about this witness, but I realized that if I called this witness, I couldn't do it because of an ethical rule, or this person doesn't exist. We have to be able to rebut. And it gets into their business. I'm not going to take an argument about if it's fair or not, because after all, the attorney-client privilege can't be a sword and a shield at the same time. But that's one of the things to think about in these motions for new trial. Suddenly, just like how we are once again producing another copy of our record, another copy of our discovery to be handed over and be fly-specked, we're now looking at what they've done too. So there's a lot of considerations about how these motions for new trial get slowed down the process and how detailed they become. And because also don't forget, you're doing this on the record. So once again, you're now looking for another transcript and the delays that get built in with that. This is not a problem that happened overnight. And I do thank the committee for their time and the level of thought that's going to go into this process. There's a very deliberative thought that needs to take place to come up with the solutions. The other thing too that I'm very aware of, and as the chairman has already pointed out once, there's a price tag that's going to come with this. And I know that this legislature has always been very cautious and very prudent in how they spend the state tax dollars. So we can come up here and say, oh yes, build us a brand new agency. Oh yes, give us extra lawyers, give us extra judges. Each one of those means that there's going to be another initiative that isn't funded or something else is going to have to be done. So I also am very aware that we can ask for a lot, but what we can get back may not be exactly what we get.
Any questions?
Down here this time.
Yes, sir.
Thank you, Robert, for your testimony. The AG, the Attorney General Office, they represent the state in all habeas cases involving incarcerated individuals?
They represent the commissioner because the way that a habeas, the warden, the way that a habeas is styled is that the inmate.
The defendant is
illegally detained.
the person who's detaining them, which would be
Yes,
the warden in this
the
case.
petitioner's being illegally detained and they name the warden as the responsible party. In that context, the Attorney General's office represents the warden.
And then there was another, on some direct appeals, did you say they also?
And I believe it's under the statute for the Attorney General's office that they represent along with the prosecutors, the state in all murder cases that are on direct appeal to the Supreme Court.
So any murder, capital and non-capital, they would potentially have a role?
Yes, they would, on direct appeal. And which also leads me to another point as well. It was mentioned about how many people are currently in prison for life and life without parole and the shift that you've seen. I'm not 100% qualified to say this, but I can give you what I understand has happened, that the drop in the two numbers, going in opposite directions has an impact when y'all change the law to allow us to be able to offer life without parole as a sentence without necessarily having to seek the death penalty. I think that's when those two numbers started shifting.
One other
Yes, sir.
follow-up. So the notion, so right now, if there's a habeas appeal, does the DA who secured the conviction have any involvement in the defense of that appeal or participation?
Only if the person is no longer in prison. If they are still suffering from a restraint upon their liberty some way, or if there is some disability that's being put upon them by their conviction, but they're not incarcerated, then we would handle those.
And is that just because of the venue rules particular to habeas, depending on the circumstances of incarceration or not?
Yes, sir.
Okay, because there, I guess, in those different cases, the person that's doing the aggrieving is a different one, and therefore the location you sue that person is different.
Essentially, at that point, you're suing the state because of your conviction.
Correct, but if I'm incarcerated, I'm suing the guy who's in charge of keeping me incarcerated, which is the warden, and that would be in the location where I'm incarcerated. If I'm suing for some kind of habeas relief with respect to some other restriction on my liberty, I assume that I would, I guess the rule is that you basically bring that in the county where the conviction was secured, because that's sort of what originates that restriction.
I believe you to be correct, yes, sir.
Okay, but that's not a constitutionally limited rule necessarily. That's a venue rule we could change.
I believe so. I'm looking over, and I think that it's a statute that says that.
So the Constitution says that venue is in the county where the defendant resides. But if you change who the defendant is, you change the venue.
Okay, so it's just the regular constitutional civil venue rule that we try, because the habeas, even though it's from a criminal case, is considered a civil case. Okay.
And in the criminal world, we lay claim to that venue provision too.
Okay. So does, do you think there is some utility in having the ineffective trial, the ineffectiveness of counsel trial, the trial on that issue in the originating court at the time it currently is required now, which is, it's supposed to be done fairly quickly because it's the first thing that happens it's not really even, in my view, in an appeal. It's in the part of the appeal that still lies within the trial court, the motion for new trial. I think the concern has been that you can't get your transcript, and you need to have the transcript to be able to make your motion for new trial complete. Do you view changing the rule on where you have to raise that ineffectiveness claim as being essential to resolving the problem? Or is it more a fact of just trying to make sure that, leave it where it is, but try to do things to juice it to happen quicker? I don't know if I made a complete English sentence for that question, but I hope you understand what I was getting after.
I think I understand enough, and I think it's not just that. That's part of the problem, is that if we shift it, and if we were to shift and say, okay, ineffective has to be brought, it can only be brought in habeas, there are other factors too that are going to go into that analysis. As a practitioner, I was always kind of like, well, why don't you keep if you wanted to keep your trial lawyer, and the one who represented you at trial, and you thought they did everything they could, in theory, you could keep your lawyer and go through the first set of appeals. It's usually not done because there's this notion of, well, part of the reason why the defendant was convicted was because there was some sort of mistake made by the lawyer, that they were constitutionally ineffective. So that's why we bring up ineffective and undirect appeal. If you move the habeas, basically the trial of whether or not the defense lawyer was constitutionally ineffective, if you move that to habeas and then put habeas at the same county as the conviction, I can see positives and I can see negatives. As my initial statement about, you're going to have judges and clerks that have resources in counties right now that have to be moved somewhere else because, let's take it, for instance, we've got a very small county that has 2 prisons in it. They have 4 judges. If you take away their habeas petitions, they suddenly now only have a need for 2 judges. Move those 2 judges to a county that suddenly has lots of criminal convictions that's doing habeas work. And I think by saying enough there, we know what that means and what the unintended consequences could be of that as well. But there's, and that gets into one of the comments that was made earlier about the death penalty habeas and how they're on a wheel. So you can your death penalty case is in one place, but your habeas judge could be from a completely different location. And there's a bit of a fairness to that. I mean, do we want to think about do we have a special habeas court or a panel of habeas judges that get dispatched throughout the state? I mean, it's one of those things of, if there's no strings attached and there's no budget concerns, how about some extra judges to help, lighten the loads that we're about to create? If we're creating a new public defender system, how about some extra, prosecutors that do nothing but appeals? Because, once again, as I mentioned, there are a good number of circuits that don't have a dedicated appellate prosecutor. And unless it's a murder, and if it's a murder case, they will have the AG writing with them. But otherwise, it's the same person who tried the case who's going to be writing the appeal.
So I take your answer to be, it would help some things, but it would have consequences we need to think through.
Yes, sir.
And we might need to make some other adjustments as part of a holistic approach to the problem.
And I want to give credit where credit was due. There was a reference to Jenga and how this is not a Jenga puzzle. And I think that is very apt, that we can't simply make one change and expect everything else to remain unimpeded or untouched. And that's why I think taking a deliberative approach, looking and figuring out, okay, if we try this, what happens with this? And it's important to start the conversation now for a solution that may be months or years down the road, but eventually we get there somehow.
Thank you. Thank you, Mr. Chairman.
Yes, sir. Go ahead.
Robert, you didn't use this phrase, but I saw what one of the majors that taught me back in undergrad that had fought in Iraq and Afghanistan both. It's called collateral damage to achieve good. And sometimes, you've got to weigh the collateral damage, and that damage may do more harm than the good you were trying to aim for in the beginning. It seems, and the rural example that you gave speaks very well to a lot of us in here, as most of us come from these very, population or less dense population centers across the state. And so what I see and what I know you and I have talked about before, and what several others on this commission have spoken about, we've actually got a current system that has huge issues that, when those originated, it seems to be very recent. And before we approach this new system, from what I'm hearing, and I think you've brought it out, and correct me if I'm wrong, obviously, but it seems like we've already got some constitutional issues with the current system we have. And would you agree with this part, that before we go forward with changing IAC, we need to make sure that we've got the current system in place as far as, qualified appellate lawyers, making sure that prosecutors have the resources they need, because I know just recently in my home circuit, there's 2 or 3 of the ADAs that are working together on appeals. Thankfully, they were successful on those appeals, glad of it, but the time and resources that are devoted to these appeals, I mean, already it's a strain, it seems like, outside of these larger circuits. So would it not be true that we may need to look at making sure that we're finding the process currently as is adequately enough before we try any changes of this monumental nature?
I think something needs to be done. I agree, and not just because he's sitting at the table and looking at me and very nervous. I agree, something's got to be done.
Tough to deny that statement.
Oh, and I'll take the next step too, and I'll agree that they're the ones that broke it. But the thing is that something needs to be done. Having practiced in the system for over 20 years, I can tell you I have seen changes. I think that we're all, and this now is going to be leveled at you guys as well, we're all equal partners in this, in terms of what needs to be done, what could be done, and how it could be done. I think I think it was Aaron who said this. We don't know what the contours are, what cards are on the table. Can we have conversations about, how resources are allocated? Can we have conversations about opt-out circuits? Can we have conversations about an additional agency to give the defendants, or the indigent defendants, a qualified appellate defense that is free of conflict? Can we have a conversation about venue? That's one of the things, and I know this is the first time we're getting together officially in a meeting. Tell us what's on the menu. Because, it's nice to walk into a restaurant and be told, okay, chef's got everything in the menu, everything in the kitchen, what do you want? A little bit different when you walk into a hamburger joint. Okay, I know I'm getting a hamburger, I've got some options within this. So let us know, because, you've heard a lot of good dreams, a lot of good ideas. And I'm giving you also some practical realities, but I've got some asks too. And, I've mentioned part of them. Another one is, y'all have done a really good job recently of making some new processes and new procedures and giving prosecution equal ability to challenge things. You never went into Title V, which is the Appellate Act. And there are certain people at the table over there who've come down and said, if it's not listed, you don't get it. So I'd like to talk to you about that. But that's kind of, a long answer to your question. But I think that there are some things that we need to look at. And there are some great ideas, but we need to look at something, because the current system is still moving forward, but the wheels are getting more and more square.
Robert, I think you and I have had this discussion before, that we've got Title 16 taking up 3 volumes of the code. And it also has in there where, and I used to tell folks back home this, if you're that mad at somebody, go ahead and hit them. Because if you threaten to do it, that's a felony. The striking of someone is a misdemeanor. So we have problems in our code that we need to fix, a lot of them. This committee can't do that, but I hear you. We need to take a look at it.
And Mr. Chairman, I would say from my perspective, I don't do this work.
Mm-hmm.
So I don't totally understand the problems. I certainly don't think it would be presumptuous of me to tell you what we need to do to fix it. I'm here to try to hear from you what you think we need to do to fix it, and then ultimately I've got to make a decision what I think makes sense. But starting out, other than what the Chief Justice has suggested in his concurring opinion, I'm not really, I don't know what the options are. So I think this has been useful for me today to try to hear some of those, but that's going to, I'm sure a conversation we're going
Been very helpful to me.
to have and on a more granular level will be useful.
Okay.
Chairman Crow had his hand up.
Oh, yes, sir.
Yeah, I just wanted to ask, speaking of learning, as the only non-attorney sitting on this committee, of course, my background is more in the enforcement side of these things, but
Source of great pride to his mother.
yes, it was. You talked about some of the unintended consequences and some of the venue changes and things like that. One thing that you'd mentioned was, and I think Ms. Arsenault mentioned earlier, with the death row inmates, there's judges that are like a lottery. They're picked out for that. Who prosecutes those cases? Who handles the side of that? Is it the Talaga Circuit that is?
All right, once a death, or the DA prosecutes the death case.
Mm-hmm.
And if the jury returns a guilty verdict, the sentence is set at death, and it's appealed to the Supreme Court, the DA and the Attorney General handle the appeal. If the conviction is affirmed on appeal and the U.S. Supreme Court does not grant review, it then goes to habeas. At that point, and within the Attorney General's office, there's a specialized unit. There are 2 different units in the appellate, in the Attorney General's office that handle habeas cases. There's the ones who handle the normal habeases, and then there's the specialized group that handle nothing but death penalty cases. And they're the ones who team up against the Resource Center, the federal defenders, the Georgia Capitol defenders, and any private attorneys that get involved on behalf of the defendant who's been sentenced to death. And they handle the habeas. The case is spun on a wheel, and one of the Superior Court judges, and I'm going to look over here and make sure I'm saying this right, a Superior Court judge who's on the list gets designated and said, this is your case, you're now the habeas judge. Back in the day, there was a special law clerk employed by the Council of Superior Court Judges who did nothing but assist those judges. I know because when I first graduated law school, one of my judges was nominated or picked to do a death penalty case. So I was assisting her, and we were working with a gentleman up here in Atlanta as we were trying to handle the death penalty habeas. So that's kind of, this was Brunswick, and I think the murder case was up here in the metro Atlanta area.
Okay, just, I got to thinking about the staffing you were talking about with judges and that sort of thing. Since the diagnostic prison and all of its death row inmates live in my district, and Butts County is in the heart of my district, it's particularly important to me to make sure we don't create staffing issues or other logistical issues for our local prosecutors and judges and clerk's office.
The way I understand it, your clerk gets additional resources because of the volume of cases, but I don't believe that you get extra judges because they have spread the wealth, for lack of a better way to describe it, split the burden, because you bring in judges from around the state to handle those.
Okay, thank you.
Yes, sir. Go ahead.
So I understand because of that so-called lottery, the lottery nobody wants to win. So if there is a murder in my circuit and I, as a DA, prosecute that, and one of the judges in my circuit tries that case or hears the case and oversees it, and then there ends up being a habeas petition filed on it, the DA who prosecuted it and the judge, a judge who's not even from our circuit might end up hearing the habeas
Yes, sir.
petition.
Part of that, and if you won't, I can't say this because I know, but this is a feeling I have. Part of that is because if we're going to ask for the ultimate sanction, we need to have as many different viewpoints and many different eyes upon it to make sure that no mistake was made, no error, no bias, no nothing, to make sure that it is clean. Because if we're going to go down that road, we have to afford every protection possible.
Well, no, and I understand that. I understand there's a strong policy argument. That just is.
But now that's death penalty. That's not normal murder.
That's only as to death.
Well, true, but those are the cases that tend to get the most attention and are viewed to be the most violative of community norms. It's just odd. That's just somewhat of an incongruity to me, although I understand it's a result of some well-thought-out policy.
Yeah, I think it is a well-thought-out policy to remove the locals and let that be kind of, because there's also a proportionality review that's done to determine that case against other cases. There's no such thing as a garden variety murder, but a non-death penalty murder, then in that case, you would have all the locals involved until the habeas. And then once again, on habeas, it's handled by the Attorney General's office, their staff, and right now, the county where the person's incarcerated.
Thank you. I want to make sure I understood sort of how that works as a practical matter.
I'm disappointed I didn't get any questions from Representative Holcomb, but I'm not taking it personally.
Sorry to let you down.
Thank you very much.
Yes, sir. Thank you. All right. Is there anybody else that wants to speak? Yes, ma'am.
And I am the new managing appellate attorney for the GPDC. And I was asked to come here today to kind of figure out what was going on and where this may be going. I've been in the office for about 60 days now, and I can tell you that we are inundated with appeals from all over the state. 95% of the appeals that come into our office to be farmed out to contract attorneys come as a result of IAC claims, ineffective assistance of counsel. And once that's alleged, of course, you're entitled to new counsel. About 5% of the cases that come in are because they're a co-defendant case. They were tried by a circuit public defender, and now they need another appellate attorney for the other defendant. And so we get those cases. And then we get about 5% where the circuit says, we just don't have the personnel. We do not have an appellate attorney. We don't have anybody that can handle this case. Right now, we have maybe about 40 attorneys across the state that can handle appeals, that are competent to do the appeals, and they are all overloaded. And so the problem that I see is that if we go to a two-tier system and we're going to need more attorneys, there just are not a lot of attorneys that want to handle appellate work. I've always loved doing appellate work. I started in the Fulton County Public Defender's Office as a trial attorney many years ago, and then I went into the appellate section. And it's very challenging work. It's very tedious work. But if you don't like to read, it's not work for you. And a lot of people don't. They want to be in a trial court. They want to be before a judge making arguments. So finding good appellate attorneys who are willing to read the record, go through the record, and make sure that they are covering the issues and finding the errors can be difficult. And that seems as if that may be problematic. I don't know what the solution is. GPDC has not formulated an opinion because, as the previous speaker indicated, we really don't know what's on the menu. But I can say that I, just sitting here listening, anticipate that finding good appellate attorneys is going to be problematic. There are good attorneys throughout the state. Some of them are very high-paid attorneys. And then to ask them now do indigent work for much less than what you could command as a private attorney may be problematic. And that's what I see as an issue. I do, personally, my view as an appellate attorney who's practiced for almost 40 years, I do see IAC claims as putting sand in the wheels. It's when I first started practicing, you handle a criminal trial, you got a conviction, you did your appeal. There were not as many IAC claims as we're seeing now, and most of the ones that we handle, the cases that we handle overwhelmingly are IAC claims. So I do think that that is a problem and it needs to be dealt with, but I'm not sure how that should be handled. And we certainly would love to work with the committee in terms of farming a solution. The GPDC realizes that that's a problem. In my short tenure in this job, I realize that it's a big problem. But the problem that we don't want to create is not having enough good qualified appellate attorneys to handle the work, which is already a problem. But it's going to be even magnified, I think, if we don't address that underlying issue. So that's basically all I had to say.
Any questions from the committee? Yes,
I have one. I'm back on it.
Sorry,
The incentives in terms of including an IAC appeal are both the mandatory nature of it. So one wouldn't want to waive that, and so it's a why not of adding it to it. And then my sense is there's also the negative aspect of now that this is so common, there could potentially be a malpractice claim if you don't include it. So it's always getting included now because of the incentives in the system, correct?
Correct. It's, and when we get what we call an appellate transfer form, the circuit sends us a form giving us very cursory facts about what's going on with the case. And then there's a space, why are you transferring this to the GPDC, IAC? And that's generally what they say. The client said I was ineffective. Well, once that's raised, they're going to automatically shift that case to us. And then, of course, we have to figure out an attorney that can handle it. Finding attorneys here in the local area is not as difficult, although it is becoming difficult because I'm looking at the caseloads, we want to keep the contract attorneys at a certain level and not give them more cases than that, because they're still running a private practice. And we realize that this is not your sole means of income. And so we're trying to limit those caseloads. So that's the big issue that I see with regard to any solution. We've got to still figure out where do we get good qualified appellate attorneys.
And recognizing that every case is different, are there commonalities in the IAC claims that are successful?
I've not been on the job, in this job, long enough to answer that for you. I'm happy to see what I can get those numbers for you and try to get that figured out. But at this point, based upon what I know about IAC claims, having brought them myself as an appellate attorney, the success rate just is not very high.
Right.
I do believe that they need to be handled at some other point in the appellate process. I think that the substantive issues overwhelmingly are where we would see reversals or remands for some various reason, as opposed to the IAC claims. I don't know, just thinking through this and hearing what the last gentleman had to say, maybe some court or some other forum post appeal that dealt only with potential viable IAC claims may be a possibility. I don't know, but I know that they are very burdensome. And once a trial attorney sees that, we get the case. And whether or not it's a viable IAC claim or not, in a number of cases, I can say that they probably are not viable, but for those 10 that are not viable, you don't want that one that is to slip through the cracks. So we take them all and then farm them out.
Well, wait a minute. So I know there's like lots of jokes and stuff like that about this aspect of legal practices. We're not supposed to prosecute claims that we know aren't viable and are frivolous and don't have merit.
Correct.
So help me understand then what is happening with these IACs, because isn't there a role for the lawyer himself or herself as a gatekeeper in this system?
There's a role for the lawyer that's appointed. So the process is, it's tried in, I came up from Colquitt County. I live in Moultrie, Georgia. So let's just say an appeal comes up through that circuit, and they allege IAC. My client says I was ineffective at trial because I didn't call his brother as a witness. Then we immediately appoint that to an outside counsel, and that attorney is then responsible for reviewing the record and then filing the appeal. Now, once that attorney gets the case, if they deem that there is a viable IAC claim, then they are to raise it. If there is not a viable IAC claim, then it should not be raised, because then it's frivolous. But at that point, that attorney has already been appointed that case, assigned that case, and will handle that case throughout the appellate process.
Okay. My sense, if I were to ask judges, they would probably say that they're seeing a heck of a lot of frivolous IAC claims and not just merited ones.
At the appellate level?
Yes.
Yeah, I can't. Once the case is assigned, then we leave it to that contract attorney to make a determination, because they're the one who's read the attorney is the one who's read the transcript, gone through the entire trial file, and it's their assessment as to whether or not the claim is in fact a valid IAC claim and whether or not it should be raised on appeal.
Okay, thank you.
Yes, sir. Thank you for your testimony today.
Sure.
Do your office, and again, this is a very rudimentary question, but your office, I guess, has staff lawyers who handle appeals as well as retaining contract, or is it primarily contract?
It's a large percentage contract. I've been in the job about 2.5 months, and it's my understanding as of last year, they had 11 in-house attorneys. As we sit here today, we have 4 in-house attorneys. As of August 1, that will be 3. We will have 3 in-house attorneys. I'm the 4th. So.
And do you cover the entire state?
We cover the entire state. except for those jurisdictions that have opted out, those circuits that have opted out, yes.
And do you, you may have been asked this, I'm sorry, I was flipping through some notes. Do you, because it sounds like you've got some experience doing this, do you have any sort of conclusion, whether it be empirical or just from narrative evidence, as to why you think these kinds of IAC claims, as we call them, have become so much more prevalent?
Well, I think we live in a much more litigious society. Attorneys are afraid not to. They're afraid of bar complaints. The one thing you know if you're a criminal defense attorney is you're going to get a bar complaint at some point in your life. You're going to, have somebody complain, their mom's going to complain. So I think that has a lot to do with it. When I started practicing back in 1980-something, because I won't age myself, although my gray hair probably does, you didn't see IA. They were far, you didn't see them very often. You got a case, you tried a case, you did the appeal. And unfortunately, that's not the case. Now, the other thing I've seen is a lot of recidivism with the recidivism statutes. And of course, that's the law. But a lot of people feel like, well, what do I have to lose? And at least that's my feeling. I don't have anything to substantiate that, but that's what, you kind of asked, what did I think? And that's.
Yeah, no, that's very responsive. I appreciate that. I mean, my sense of it was perhaps folks, apparently the current data suggests they aren't terribly successful, that your chances of success are not that great. So maybe folks felt like, well, I'm not going to spend all this time on a claim that I think is not going to be successful. Now perhaps the litigants drive that more because they can't understand how in the world they didn't get off, And one other issue, did I understand you to say you feel that delaying the requirement to raise the ineffective assistance of counsel until the habeas position would require additional appellate staffing as opposed to the current system?
I think it will require additional staffing because at that point, and from what I think I kind of heard the Chief Justice saying, I hope I'm not misinterpreting, that in some limited habeas cases, there'd have to be an appointment of an attorney. And so where do those attorneys come from? If you're already.
I see, so that would cause, because right now you're not entitled to counsel on a habeas?
Correct.
Okay, thank you, that's good to know, I appreciate that. Thank you, Mr. Chairman.
Anything else? All right.
Thank you.
Thank you, ma'am. Anybody else that didn't get signed up to speak that wants to speak? Come on up.
Good afternoon. I'm Christina Cribbs. I am an attorney here in Georgia. I've been practicing for 16 years. I'm not going to go through everything, but I did work in the appellate division of GPDC before it was effectively disbanded in 2020, and I currently work at the Georgia Innocence Project. These are my own comments, not representative of the organization. I just wanted to put a fine point on one thing that's kind of been mentioned by multiple folks that have spoken, and that is just, I hope that we will all consider carefully and be wary of building a system where we are asking people who are indigent, incarcerated, and not legally trained to discover and articulate claims of ineffective assistance well enough such that they are appointed an attorney. That is not a good place to be, in my view. Excuse me. And as an attorney that's represented indigent and incarcerated folks who have been successful with ineffective assistance of counsel claims, both on habeas and direct appeal, there are certainly human beings who are going to fall through the cracks of a system where they're required to come up with those legal claims on their own. And I just think that's, something very important that we should all keep in mind, given that all of those folks are guaranteed effective assistance of counsel by our Constitution, here in Georgia, and of course the United States Constitution. That's all I want to say.
Any questions?
Thank you so much.
Thank you. Anybody else? Last chance. Yes, sir.
And this first observation is not any criticism of Ms. Harrison, because I know she's very new to the agency, but she pointed out, she made the point that it would be difficult to build an appellate division because it's hard to find good appellate lawyers. We've had a very good appellate division of GPDC, and the current director of GPDC destroyed it. And so it's not hard to build a good appellate division, and I am highly confident that the next director of GPDC can do that. Or if there's a appellate defender office created or something like that, I think that won't be hard to build out either, because there's a lot of great public defenders out there who care about doing appeals and doing them well, and have done them historically. They're just not willing to work in this particular agency at this time. That's point one. Point two is, the one thing you have not heard from anyone who has spoken today is that the status quo is acceptable. And I know you've each heard that. The status quo is not acceptable. It doesn't work. And on the occasions that we reverse convictions, either someone has spent far too long in prison and were entitled to get out earlier, or the district attorney who's going to retry them is now behind the 8 ball because they've lost witnesses, memories have faded, and victims are not going to receive justice as a result. This is not something that gets anybody elected. This is not something you can run on. But this is absolutely core to the rule of law functioning properly. And I am deeply grateful to each of you for taking the time to focus on it, and to the speaker for making this a priority by appointing the committee. So thank you.
Mr. Chief Justice.
Yes, sir.
I keep waiting for somebody to tell me some state or some model that we could follow. Is there, have you read, or are you familiar with something that you would suggest that we go to?
So I have not done the broad 50-state research that I know Gactel mentioned they're working on. I am hopeful that there is. There's enough other people who do it.
Thank y'all, and be looking for the next.
Sorry, glasses.
All right, hang on a second. Who's this?
This is the committee meeting.
Oh, yeah. We have a committee meeting on the Court of Appeals in Dahlonega at the North Georgia College, or it used to be North Georgia College, it's University of North Georgia, in Dahlonega, where we're going to be talking about the Court of Appeals and its workload and what solutions we might come up with to help with that. And that's at 1 o'clock, July 24th. And does it say where on the, in the?
It's on the website.
It's what?
It's on the website.
What website?
The House website.
Oh. Okay. You can find it on the House website. I'll have trouble finding it myself. So, all right. Thank y'all for being here, and have a good day.